An immigration lawyer is warning against giving officials more power following the release of a report today into how convicted Czech drug smuggler Karel Sroubek was granted residency. The report by Mike Heron QC recommends future decisions should only go to the immigration minister as a last resort. And in those circumstances, the minister should expect free and frank advice. The minister, Iain Lees-Galloway, came under fire for his decision to grant Karel Sroubek residency, a decision which he later reversed after the opposition began drip-feeding information about Sroubek's chequered past. Hamish Cardwell spoke to lawyer Richard Small, who says it's a bad idea to change policy based on high-profile cases like Sroubek's.
There were particular problems with the Sroubek case that are unique to high-profile cases, but it's important we don't throw the baby out with the bathwater. We need to continue to have reasonable access to someone independent outside of Immigration New Zealand as a last resort. And the devil is in the detail, but I am concerned at the idea that the suggestion isn't already a very significant filtering process before any case gets before the minister. That just isn't correct. Already, most cases go to a delegated decision maker. They are senior immigration managers, and as Mr. Heron QC has said, they are very experienced. But there's one unique quality that is lacking, and that sometimes is independence, particularly when there has been quite a contested series of events of unfairness from Immigration New Zealand that has got people in that position. And that's where I think we still need the minister standing outside the organisation and looking in on behalf of the public and the public interest.
So you don't agree that it's a good idea to kind of empower officials more going forward?
I think they're already very significantly empowered, and to some degree that's appropriate, but I would be very wary of concreting over what is already a very strong glass ceiling. Many cases are bounced down just by the private secretary, who is not a very senior immigration manager, without any consideration of the merits. And again, it's really important that we don't create unintended consequences on the basis of a couple of high-profile cases. So I'm in favour of keeping access to the minister and being very clear about what last resort means, because there are cases that have already been in the hands of the immediate circle of the managers who then, as DDMs, refuse them. I'm saying that's unfair, and that there is a lack of transparency on occasions, that we have multiple complaints about alerts and other background material, so-called withheld under security grounds, not being disclosed, and you need someone independent in the system, and I'm concerned that this removes another layer of independent scrutiny.
Immigration lawyer Richard Small speaking to Hamish Cardwell there.